If you've recently moved or are planning to move, you've probably wondered, do I need to update my trust? It's one of the most common questions I get in my practice, and the answer isn't as simple as yes or no. Hi, I'm Chuck Roulet. I'm an estate and elder law attorney licensed to practice in both Florida and in Minnesota, and I've been helping families protect their home and life savings for nearly 30 years. And today I'm going to walk you through exactly when you need to update your trust after a move, and more importantly, the steps you should take to protect your family regardless of where you relocate. Now, whether you've moved across town or across the country, by the end of this video, you'll know exactly what you need to do to keep your estate plan working properly. Now, before we begin, if you haven't already, make sure you click the like and subscribe button so you'll be notified when I post new videos like this one. If you have a question, post it in the comments below and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. Now, I want to be upfront with you. I've been interviewed by USA Today, Live Life Large, Money Matters, CNN, the Epic Times, and others on these topics. And I teach continuing education to other attorneys and professionals around the world. But I'm not here to overwhelm you with legal jargon or scare you with horror stories. My goal is to give you clear, practical guidance based on real situations I see in my practice every day. So let's dive into the two main scenarios you might be facing. So scenario number one is that you're moving within the same state. So let's talk about that first. Well, the good news here is that your trust document itself typically doesn't need to be updated. The laws governing your trust remain the same, so the structure you put in place continues to work. However, there's one critical step that many families overlook, and it can create significant problems, and that's the property transfer issue. When you purchase a new home, you need to make sure it's properly transferred into your trust. So here's what often happens. You set up your trust, you worked with the attorney probably prepared a deed to put it into the trust. However, when you buy the new home, you work with a real estate agent and title company who may not be familiar with trust-based planning. And so they put the deed in your individual names because that's what they're used to doing. So let me share a real example. John and Susan moved from one suburb in Minnesota to another. They had an excellent estate plan in place, but when they bought their new home, the deed was put in their individual names and not their trust. So when John and Susan passed away, their kids discovered that the house would need to go through probate before they could sell it, even though John and Susan had a trust. And this meant additional time, expense, and court involvement that could have been avoided. So the solution is straightforward. Ensure your new home is transferred into your trust through a properly prepared deed. It's not complicated, but it needs to be done correctly and recorded with the county to be effective. Now, while we're talking about property ownership, there's something else you should understand about how you hold title to your home, especially if it's not in a trust. When married couples purchase real estate, they can take ownership as either joint tenants or tenants in common. And most people don't think much about this choice, but it can have significant implications. Joint tenants means that when one spouse passes away, the surviving spouse automatically becomes the sole owner. There's no probate required for that transfer. However, you need to be aware that probate isn't avoided entirely, you just kick the can down the road. When the surviving spouse passes away, unless the home was put into their trust or some other planning was done, the kids or other family members will still need to go through the probate process in order to get the legal authority to sell it. Now let's talk about tenants in common. Tenants in common means each spouse owns their separate percentage, typically 50% each. Now, when one spouse dies, their share must go through probate before the surviving spouse can gain full ownership. So if you're tenants in common and your property isn't in a trust, your family could face probate twice. Once when the first spouse passes, and again when the surviving spouse eventually passes. So the key takeaway, if your home isn't in a trust and you're married, joint tenancy typically provides better protection for the surviving spouse. That being said, in order to avoid probate entirely, additional planning still needs to occur. Now let's talk about the second scenario, and that's where you're moving to a new state. So if you've moved to a different state, the situation becomes potentially more complex. While your trust doesn't automatically become invalid, it's important to have it reviewed by an attorney in your new state. Think of it this way. Each state has developed its own legal framework over many years. What provides excellent protection in one state might not offer the same benefits in another. For example, some states have different requirements for how trusts must be administered, how powers of attorney must be executed, or what language is needed in healthcare directives. I regularly review trusts that were drafted in other states but need adjustments to work optimally under Minnesota or Florida law. And since I practice in both Minnesota and Florida, let me use Florida as a specific example. Florida has some unique advantages for residents, but also some stricter requirements. For example, Florida offers excellent asset protection through its homestead exemption. Your primary residence can be protected from most creditors, regardless of value. Florida also caps property tax increases at 3% per year under the Save Our Homes Amendment. However, to maintain these protections, your trust and the deed transferring your property into the trust must contain very specific language. Generic language that works in other states may not qualify for these Florida benefits. As an example, I recently worked with a couple who relocated from Illinois. Their estate plan was well crafted for Illinois law, but needed specific updates to take advantage of Florida's protections. We were able to preserve their homestead benefits and ensure their plan worked properly under Florida law. There's another consideration when moving to a no-tax state like Florida. Some high-tax states are quite aggressive about challenging former residents who claim to have established residency elsewhere. And having your estate planning documents updated to operate under your new state's law can be one factor in demonstrating that you've truly established residency here. Now, it's not the only factor, but it can be an important piece of the overall picture. So when you move to a new state, it's not just your trust that should be reviewed. Your entire estate planning portfolio should be evaluated. This includes reviewing your powers of attorney for financial matters, reviewing your healthcare directives and living wills, reviewing your HIPAA authorizations, and reviewing your pour-over wills that work with your trust. Each of these documents may have different requirements in your new state. Again, for instance, Florida requires very specific language and powers of attorney that other states don't require. So the goal isn't to redo everything unnecessarily, but to ensure your documents will work effectively when your family needs them most. So let me give you some practical guidance based on what I've seen works best in my practice. So if you've moved within the same state, first, ensure your new home is properly transferred into your trust within 30 days of closing. Don't wait. It's easy to forget, and the consequences can be significant for your family. Second, if your home isn't in a trust and you're married, verify that you're holding title as joint tenants rather than tenants in common. Then work with a qualified estate planning attorney to prepare the appropriate estate planning documents if you would like to avoid probate. Now, if you've moved to a new state, schedule a consultation with an estate planning attorney in your new state within 90 days of your move. This doesn't necessarily mean starting over. It means making sure your existing plan works optimally under your new state's laws. And be particularly diligent if you've moved to a state with unique benefits like Florida's homestead protection or specific requirements like Florida's stricter document execution standards. So here are some general best practices as well. First, keep copies of your estate planning documents easily accessible and make sure your family knows where they're located. Second, review your plan every 3 to 5 years or after major life changes like moving, regardless of whether you change states. Third, remember the goal of estate planning is to make things as smooth and inexpensive as possible for your family during difficult times, and proper planning after a move is part of that process. So I hope this has been helpful in understanding when and why you might need to update your trust after a move. And remember, every family situation is different, which is why it's important to get personalized advice for your specific circumstances. Now, if you need to create a plan or update an existing one or would like to discover more, visit us at rouletlaw.com. For those of you who would like to discover more about the legal steps required to establish Florida residency, I've written a comprehensive guide called the Florida Snowbird Guide, a fast and friendly legal guide for Florida relocation and snowbirds. It's available for sale on Amazon, or you can download a complimentary digital copy through the link in the description below. I'm also hosting an exclusive online masterclass where I'll be revealing strategies I use with my private clients to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. Join us by clicking the link in the description below to sign up. Remember, this information is educational and not intended as legal advice for your specific situation. For personalized guidance, please consult with a qualified estate planning attorney in your state. I hope you found this video helpful, and I look forward to seeing you in an upcoming video and the masterclass. Be well.